We will move to the next subject. Next subject is arrest beyond territorial jurisdiction. Arrest in case of multiple FIRs in same state or different states. And what are the safeguards? And international and UN standards on the arrest. We have seen some dirty clashes between the Delhi, Haryana and Punjab police recently while trying to take in custody of some accused. Now, this will be delivered by Shri HS Sandhu. He is a 1983 batch IPS officer of Manipur cadre, Manipur and Tripura cadre. But a very experienced officer who has done a large part of his tenure abroad. He worked for 5 years in CBI, 5 years in Interpol. Then he was part of UN Security Council. He also worked for the UN tribunals for the former Yugoslavia and Lebanon. And I think his last posting was with the UN World Food Program as an anti-corruption expert. He has been an independent expert to the UN Counterterrorism Committee, UNODC, Serious Organization Crime Agency. So, sir, I would request you to take this session, but 12 minutes, please.
Thank you, Dr. Ish Kumar. Having listened to some really distinguished speakers, and especially the way Mr. Ramachandran himself started it, I think he virtually set the tone and covered everything. Then Kumawat sir and Mr. Barkat Ali, everyone. I don't want to spend more time on appreciating everyone because the time is very limited. So since there are 3 parts in the presentation, so I will have to take like 4 minutes each. I did prepare some PowerPoint presentation last evening, thinking that at least we should share something with people, because listening sometimes network is not good, sometimes whatever reason. So at least something is shared with that. And thank you, Dr. Ish Kumar, for giving a nice introduction. I try not to put too many things, but still is fine. So there are 3 subjects like arrests in cases of multiple FIRs for the same offense in different police stations or other states. Then we have safeguards and procedure for arrest from a different state, avoiding clashes, so that, and third, international UN standards. So I will try to quickly run through. The first one, when we talk of multiple FIRs and arrest in these.
Sir, can I make a request, sir? Can I make a request, sir? Sir, yes, international and UN standards on the arrest would be more interesting for everyone because we are not aware.
Yeah, sure. I will very quickly go through that.
Maybe you can start.
I will rush through and then share with you the presentation, and then you can later on. You can definitely share with everybody. Okay, yes, I will go to the. Okay, let me go back to my presentation. Yeah, sure. Sorry. I will rush through that. We already saw this. No, question of maintaining second and subsequent FIR. This I will touch in a minute or so. Why it is not allowed? Because the impermissibility of registering multiple FIRs. There has been a lot of talk, discussion, so many cases, even CRPC says something, and so many cases, Anju Chaudhary case, Upkar Singh versus Ved Prakash and all. Why this impermissibility is to protect the fundamental rights of an accused against double jeopardy, and to maintain the rule of fair investigation, and to not allow the police to abuse their investigative powers under CRPC. Then again, it comes same offense or same kind of offense. Previously, courts were accepting that same kind of offense is okay, but then, you know, there are quite a lot in state of Jharkhand versus Lalu Prasad 2017. Then they say, no, it's not same offense. It is same kind of offense. So this all, I'm skipping over that. The test of consequence came in that, then the same cause of action. But a bit of that I will read from Arnab Goswami 2020, where the court said whether multiple FIRs can be filed. So that again is worth reading. they say that lodging multiple FIRs is not permissible. So if lodging multiple FIRs is not permissible for the same, obviously you can't arrest the same person for each offense in various places. Court was conscious of this fact. Then where it is allowed is based, where it is counterclaims are there. We saw that even Delhi riots also, those judgments were like they all were quashed. 4 of those FIRs were quashed in that. Coming to this, this is important before going to international. The second part, the first I skipped, safeguarding and procedure for arrest from a different state, avoiding clashes. Dr. Ish Kumar mentioned about this, what happened in Delhi. Punjab police came to arrest the person. They picked up, they claimed that they had already reported to the local police denied it. When they were taking it, what drama happened in Haryana, the person brought back. We all have seen that. So rather than discussing topic of justice, the matter turned into topic of political rivalry. Then Supreme Court's observations in Riya Chakrabarti case, again also when the Bihar police had gone there, the drama happened. We all have seen that. But when we come to interstate arrest guidelines, the best set of guidelines came as a result of Sandeep Kumar versus the state. I think each and every police officer, if has not read it in India, should read the detailed judgment of Justice Muralidhar and Talwant Singh, where resulting from that habeas corpus plea, where somebody was picked up from JNU and all that. So, you know, this is where the court says court cannot condone lawlessness by police. So then they constituted a committee for inquiry into that case, consisting of High Court Judge S.P. Garg and IPS officer Mrs. Kamalji Deol. They issued very, very detailed guidelines. So if you read those guidelines, there is nothing that leaves it. There should be no doubt after that. So I'm not, it is, the guidelines run into like 4 or 5 pages. So I will not go through that, but it says just 2 or 3 of those I'm mentioning. Police officer must seek permission from his superior in writing or in emergency. Then must record reasons for such a move, and police must endeavor to establish contact with the local police in other place. So I'm jumping over that and straight going to, in fact, I wish I had covered that, because on the interstate guidelines, I wanted to touch on each and every guideline on that, what is to be done before proceeding, after reaching there, and on return, what are the steps to be taken? All details are given. So as Dr. Ish Kumar said, I jumped to the last part, and there I will put some time. International UN standards of arrest. The very milestone document behind that is the Universal Declaration of Human Rights. It is a milestone document in the history of human rights. This was adopted on 10 December 1948, and in the drafters included people from almost all the countries and various strata, the experts, the lawyers, everybody virtually. And it has 30 articles, which are very detailed. But Article 9 is the one that we just need to refer. Very small sentence, Article 9. That is the very foundation of international UN standard of arrest. Article 9 says, no one shall be subjected to arbitrary arrest, detention, or exile. It's so simple. No one shall be subjected to arbitrary arrest, detention, or exile. And based on that, then they set a body of principles for the protection of all persons under any form of detention or imprisonment. This body of principles was adopted on 9 December 1988 by the UN General Assembly by the Resolution 43/173, and it gave 39 principles. So these 39 principles are exclusively for protection of persons under any form of detention or imprisonment. Out of 39, 5 or 6 I have singled out, which really are very, very relevant. No, all are important, but just a few one. Principle 1, just keeping the time in mind, and I will share this presentation so it all, you will have it. All persons under any form of detention or imprisonment shall be treated in a humane manner and with respect for the inherent dignity of the human person. This was principle 1. Principle 2 is that it must be carried out strictly in accordance with the provisions of the law and by competent officials or persons authorized. Principle 6 says no person under any sort of detention shall be subjected to torture or to cruel, inhuman, or degrading treatment or punishment. No circumstance whatsoever may be invoked as a justification for torture or other cruel, inhuman, or degrading treatment or punishment. Sadly, India is not a party to the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment, commonly known as UN Convention Against Torture. So, India has still not signed it. Principle 10, anyone who is arrested shall be informed. It's important at the time of his arrest of the reason for his arrest and shall be promptly informed of any charges against him. Principle 11, effective opportunity to be heard should be provided promptly by a judicial or other authority. A detained person shall have the right to defend himself or to be assisted by counsel as prescribed by law. A detained person and his counsel, if any, shall receive prompt and full communication of any order of detention together with the reasons thereof. A judicial or other authority shall be empowered to review as appropriate the continuance of detention. Principle 12.
Sir, two more minutes, please, sir. Sir, 2 more minutes, please.
Yeah, sure. There shall be duly recorded the reasons for the arrest, the time of the arrest, identity of the law enforcement official, and precise information concerning place of custody. And principle 13, again, another very important one, which we always carried in all the international investigations. Any person shall at the moment of arrest and commence of detention, etc., must be provided information on and an explanation of his rights and how to avail himself of such rights. I have put here a picture which we arrested some people, very high profile, including a sitting prime minister, sitting foreign minister, and all from Kosovo and other Yugoslavia tribunal, going with over hovering helicopters and with the NATO armed groups supporting us. But immediately on arrest, we provided this information to the person. What are your rights? This is very important. It's not that mistakes do not happen. Sometimes they do happen. But then we follow the procedures internationally. The focus is on procedures and integrity of the process. And all investigations are based on principles of independence, impartiality, and credibility. So that is why even if there is a mistake, because once we picked up a wrong person, he was identified wrongly, and still after bringing him to Hague, it was the prosecution, the investigation itself which pointed to the court that we picked up a wrong person. We did not try to put him through any further, and even his defense team was appreciative of the investigation and the prosecution. In conclusion, I won't even go 1 minute above. In conclusion, I will use Mr. P.V. Rajgopal's one quote, which he put it in the email on Top Cop recently. He said that Sardar Patel, addressing the passing out parade in Philor in March 1949, had exhorted all the policemen with this: do nothing that will dishonor the flag you salute. Do nothing that will discredit the uniform you wear. We need to arrest our we need to arrest our temptation to arrest and the power to arrest. that is where the authority and discretion is abused. Having a discretion is good thing. I think just Dr. Mohanty also said, is only how we use the discretion. And some people talk of having more legislation, the law should have more teeth. My take on that is always, no, we do not need more laws. We have enough. We need a more rational dental arrangement and a will to chew. And senior officers need to step out of their ivory towers and see what their men are doing on the ground. The great K.F. Rustamji had written that time also that most of the district officers and senior officers just jeep through their tenures and do not get out of their place to go and see what their men are doing on the ground. That they need to do a lot. And just to stick to the time, I will conclude with that we have enough everything, is only how we implement it. Each of these issues can be discussed at length. So with this, thank you very much. Thank you for this opportunity. Of course, in the discussion subsequently, we can further talk. So Dr. Ish Kumar, back to you. Thank you.
Thank you, sir. Thank you for that exposure. You made number of important points. One about the Article 9 of the UDHR, and then body of principles of 1988. You also mentioned that the UN Convention Against the Torture, India has not yet signed or ratified. And then, of course, you spoke about the Sandeep Kumar judgment, which gives detailed instructions on the arrest from the other states. Of course, icing was the Sardar Patel's observation at the passing out time. So thank you very much, sir, for those things.